Okay, so we are live. Welcome to all our audience and all our viewers and Professor Glynn Lunney, who is a distinguished professor at the Texas A&M University of Law. And we are going to have a conversation on various kinds of topics related to intellectual property law, Texas careers in academics, and we will also get a lot of insights. We hope to get a lot of insights from Professor Glynn Lunney's own career journey as an academic and a practitioner. Professor Lunney was an engineer at Chevron a long time back, and before he himself got into academics and teaching. So I'm going to uh, ask Professor Lunney to share with our viewers his, Professor Lunney, thank you for being here. If you could please share your career journey with all of our viewers and, introduce yourself a little.
I'd be delighted. So I'm Glynn Lunneys. I grew up here in Texas. I went to Texas A&M as an undergrad. In the United States, law school is a graduate degree, so you have to do something else for your undergrad.
Would you please increase the volume from your end, Professor Lunney? I'm sorry to interrupt.
You can't quite hear me, huh?
It is not loud enough. Could be a bit louder. Just please here.
Is that better?
Yes, yes.
So as I was saying, I went to Texas A&M University for my engineering degree back in the early 80s, graduated with a BS, Bachelor's of Science in Petroleum Engineering. And then I went to work for Chevron for several years out in the Los Angeles basin as a production engineer. In the late 1980s, I went back to law school. I went to Stanford in Palo Alto, California, got my law degree, and then I moved to New Orleans to clerk for a federal judge there named John Minor Wisdom, who was on the United States Court of Appeals for the Fifth Circuit. After that clerkship, I practiced and taught in New Orleans area. I taught at Tulane University School of Law. While I was there, I went back and got my PhD in economics because, nothing else to do with your time, so you might as well get a PhD. And then I went and came and joined the Texas A&M faculty when A&M acquired its law school in 2013. I joined the faculty as a joint appointment for both the School of Law and the College of Engineering in 2015.
So you have degrees if I may ask you a question, Professor?
Sure.
You have degrees in engineering and in economics and in
law. Oh, wow. Yes. People sometimes ask me what I want to be when I grow up. And I tell them I'll let them know when I get there.
Okay. Great. And what subjects do you now teach?
So this particular semester, I usually teach a first-year course. So law school in the United States for the basic Juris Doctorate program is a 3-year curriculum. And your first year is the basic courses. And then second and third year, some additional basic courses, but also electives so you can specialize in what you want to practice in. So this semester I'm teaching torts, which is an introductory course for the first year students. And I'm also teaching an intellectual property course for the engineering school, for the engineers there.
So could you tell us more about the the IP courses that you are teaching for, are you teaching law students IP as well?
I usually do, but not this particular semester. So it's just the engineering students, but it's the same basic course I teach to the law students, whether they're in the JD program or one of the master's programs. And this particular course is the Intellectual Property Survey. It covers the 4 main, in our country, federal statutes on so-called intellectual property, very broadly defined. So we have patents, copyrights, trademarks, and then trade secrets, and then a few miscellaneous, largely state law issues, such as covenants not compete and other contracts, and the right of publicity, the ability of celebrities and others to license use of their name or likeness for advertising or promotional efforts, marketing campaigns of one sort or another.
So, intellectual property survey, incidentally, is a subject in the Texas A&M University's LLM, which is being launched online. and which has 20 scholarships uh, for students in India. Uh, so I just had this question. There are other subjects like copyright, trademark, patent also. So how is what is the survey subject like? What is covered? What topics are covered? Are we covering the whole framework of IP law in that subject? Um,
So when I went to law school back in the late 80s, intellectual property was not as important economically as it is today. And so most law schools typically only had one faculty member who would teach intellectual property, often as a sort of side gig to their main focus. Sometimes it was specialized in that area. So at Stanford, I had Paul Goldstein, who was a world-renowned copyright expert. He taught the intellectual property survey course, also taught an additional advanced course in copyright seminar. But the IP survey has long been intended to give students a framework of the whole field, right? At least an outline and understanding of the basic statutory structure and the relevant doctrine in each of those statutory areas. So it's enough to see if you want to get into the area, and then you could pursue more coursework on your own. It was also enough so that a lawyer who was in general practice could be aware of an intellectual property issue when one came up and refer it or get assistance from someone who was more specialized in intellectual property matters. Today, almost all of the law schools, and certainly A&M, have far more robust intellectual property programs, not just one faculty. At A&M, we have 4, including myself, that are devoted full-time, and probably another 2 or 3 that work to some extent part of the time on intellectual property matters. So we not only have the survey course covering the basic matter, but then we have specialized courses in copyrights, patents, trademarks, trade secrets, each of them covering in depth what we may be able to spend only a few class periods on in the survey course, because in the survey course, you're covering so much, you necessarily are not able to cover it at quite the depth. You can cover it in a more specialized course.
That's great. Could you elaborate more on how IP has been changing over, I'd say, the past few years, but yes, even the past few decades? It would give our viewers a great sense of perspective.
So there have been a number of changes to intellectual property over the past decades. I mean, since I started practicing in 1990, when I did, intellectual property was sort of a quiet backwater. Sure, patents were important, trademarks were important, but we didn't really have much of the things we have today with the internet, the celebrity culture we see today. All of that has been enabled, and sort of companies can secure their interest in the things they create through intellectual property. And so there are various statistics people throw out about how important intellectual property is these days in terms of its contribution to economic growth, its contribution to the GDP or employment or what have you. Not comfortable with all those statistics, but it's certainly been a very important part of our economy. In the United States in 1982, we got the creation of a specialized patent court, the Federal Circuit. And since then, intellectual property of all sorts has just increased radically in value and importance to the economy and in terms of legal practice. The students who come into A&M, particularly those who have in the United States, in order to practice patent law, there are different types of patent law. But in order to draft and file patents with the United States Patent and Trademark Office, you have to be licensed to practice before the Patent Office. You have to take and pass what's called the patent bar. And so generally you need a hard science background to sit for the patent bar. And students who come into A&M with that sort of hard science background and want to do patent law of that sort or patent litigation, we can find them jobs readily as they graduate from the JD program.
So how are you able to, so in what way are the career opportunities bigger? As you said that in the past few decades, the number of new industries have made it, have grown the opportunity for IP lawyers, because, and the need for IP, because there is internet, there's technological advancement, there is celebrity, sports persons rights, name rights, image rights, all of these Then there's licensing and monetization of IP for various industries like hospitality, restaurants, various kinds of industries. So now, how has this led to creation of what kind of job opportunities has this created, as in comparison to say 1990s when you first started practicing?
Well, the easiest sort of analogy from my perspective is just to look at the number of faculty at each school that teach intellectual property. That's one way to measure the importance of
Right.
intellectual property, because schools hire when there's a demand and students want the field when there are jobs in it. So it's one measure. And so when I started teaching at Tulane in the early 1990s, there was only one, me, who really taught intellectual property full time. And that was pretty much typical for all but a very few schools. And so that's changed radically. So there, as I said, there's 4 full-time faculty at A&M. Even a school like Tulane that doesn't focus as strongly on its IP faculty now have 2 that do it full-time. So it's doubled. But a lot of schools have really geared up their programs because there are a lot more jobs. If you look at the most valuable companies in the world today, most of them were not there at all or barely there when I graduated from law school in 1990. Wow. So you think about Google or Meta or Apple was around, but just barely around in 1990. Microsoft was just getting started, right? It really came on the scene in the early 80s. But it didn't become the behemoth it is today until the 90s sort of progressed along. So we've seen these companies come along that rely almost exclusively or to a large extent on their intellectual property to protect their assets and what's really valuable to them and enables them to earn the very high profits. We don't see the old traditional sort of more assembly line situations. So it's not the car companies. Occasionally the oil companies make it back up there depending on the price of oil. But it's mostly these newer businesses that have focused on creating new things and offering new things to consumers. And if they want to succeed in that business, they need to have a very successful and appropriate intellectual property model to protect what's really valuable to them.
All right. So basically, the industries have expanded and diversified. Technology has advanced. Jobs have increased. Law schools have increased teaching faculty, and number of students opting for IP have increased. And this is this is needed because the number of jobs has increased drastically. Would this be correct to say?
That's exactly right.
Awesome. And I want to know what would be your, how does how long did you practice as an IP lawyer? And in what way have your experiences as an IP lawyer and as an engineer helped you in your academic journey as a professor of IP subjects?
So my practice experience has been largely while I've been serving in academia. So I clerked for the federal judge.
Sorry, I couldn't get that.
So the practice experience I have has largely been working for clients while I've also been an academic, primarily at Tulane in Louisiana. So I'd get clients coming to me with an IP focused issue, and I usually would associate with a firm from the downtown pool of firms in New Orleans. There were a few that I relied on very extensively. And we'd handle the case together because as an academic full-time, that's really my focus. And when I would get a case I needed to practice on, I'd need someone else who could be at the hearings and other things where you have to be there, just in case I also had to be in class at the same time. But I've worked on patent cases, trademark cases, copyright cases, both as an attorney and as an expert witness. I'm often called by attorneys to come in and testify. I was doing some work for Apple Computer just a few years back as an expert witness in some patent litigation. As it turned out, it was sort of on a copyright issue within the patent litigation. But Apple, Fox, when Exxon sued Fox Networks, which is major broadcasting networks here in the United States, I was brought on as an expert witness in that case as well. So I've served both as a lawyer and as an expert witness. Now, I've also, as an academic, testified to Congress about copyright issues and testified to the FTC and other administrative agencies about trademark, copyright, and patent issues. I've testified before the European Commission on copyright issues. So it's not just that I sit in my ivory tower and expound on the wonders of intellectual property, right? I have very real world practice experience trying to influence the shape of copyright and patent and trademark law in ways that I think will promote the welfare of society. In terms of my sort of diverse educational backgrounds, or engineering, law, and economics, people think that there are three different degrees, and of course they are, but they share in common that they're all trying to solve a problem. So in engineering, petroleum engineering, you're trying to get the oil out of the ground, over to the refinery, get it refined, get it out so people can use those resources. In law, people are coming to us because they've been wronged in some way, or they need protection against people taking their intellectual property, their ideas, their intellectual creative efforts. And so that's, again, a problem you need to solve for them using the tools that law gives you. And economics is sort of the same way, how to understand the economy to make it work better, to make the economy function more efficiently, make the law function more efficiently so that we can achieve the results we're shooting for. So they're all problem-solving approaches, and that's really what I emphasize in my own teaching. You're going to be working for a client who's going to have a problem in one regard or another. They may have been sued, they may need to sue, they may just need a sensible in-house program for protecting their intellectual property assets. And you, as their lawyer, it's your job to solve that problem for them in an efficient, cost-effective manner.
That's amazing. I understand that, Professor, you are going to be a tentative faculty in the online LLM program of Texas A&M University that's going to start in a few days from now. But I'd like to know if you could share some. So you gave us so many examples of how you've worked on practical matters on real life matters through your teaching experience, and it would be really amazing for people, to learn from somebody like you. Your students anywhere, that's a great honor, because in India we always aspire to be learning from practitioners, and it is that doesn't happen most of the times, because faculty usually has a theoretical experience. So I'm really inspired by all the experiences you shared, and I was wondering if you could maybe share some recent examples of or maybe an example of a kind of matter you worked on, and what kind of a IP issue was there, maybe on patent or trademark or copyright, whatever feels comfortable and whatever comes to mind. Because we keep thinking that what is the IP landscape there in US as compared to India. So comparison would not be needed, but we just would like to know about the IP landscape in US. And definitely, I think the US IP market is huge. I was checking statistics. So India's entire legal industry is worth $2 billion right now, and the IP industry in the US is $18 billion.
Yes.
So IP alone is 10 times the size of the entire legal industry. So that is why we are so curious to know, about some that you may have done.
We can talk about sort of the most recent matter I was working on, which is the Exxon versus Fox networks. So it was a trademark dispute. And if you're familiar with Exxon, which is a major oil company in the United States and around the world, in their logo, the two X's, EXXON, are overlapped, so that instead of 4 different cross strokes, you just have 3, and one of the strokes crosses both of the X's. So
shall I show them the logo?
Sure, if you'd like.
Okay, I will show it just so that people benefit.
Sure.
I will do a screen share. Oh, Rudresh, can you please allow me to screen share here? So that as Professor Lunneys is explaining, I could probably, people can follow it much better. Rudresh, you need to be allowing me to screen share, please. Thank you so much. So yes, here is the logo.
Right, so you see that one hash crosses both of the X's.
This
So
is
we can, Fox Network has expanded it. It's a major television broadcaster and now a television network in the United States. And so they begin offering sort of variants of the major broadcast network. And so the first was FX. And so they offered various programming, sort of tended to skew towards a male demographic, a little more action oriented. So not romantic comedies, but more action oriented films and TV series. Well, then they eventually expanded their brand to a third and fourth network. And so one of those was FXM, which was Fox Network Movies, essentially. And so it'd be action oriented movies. And then the other was called FXX. And I assume that meant that it was even more, right, extra, even more X than you had before. So even more action. So if you could pull up the FXX logo for Fox Networks, we can show that.
FXX logo Fox Networks. This is so enjoyable.
Yes.
I'm just going to share my screen again.
There you go. Let's take a look at it.
Uh,
So the one on the left and the three of these four, so Fox Network Groups is the third one, but the one on the left and on the right, you can see down here in the lower left, this is what the lawsuit came out of, where they have the Exxon and the FXX side by side in the bottom right corner. So you can see that FXX has the overlapping X's as well, right? It's using 3 lines to draw 2 X's, though it's in a different direction than Exxon. So, but that sort of difference
when
is
Exxon, the line is this,
is going left to right,
and here it
FX
is
right to left,
okay,
upper right to lower left.
right.
But for some reason, right, there are a number of firms in the U.S., Walmart, Exxon, Monster Energy are a few of them, that are very relentless and aggressive in enforcing their IP rights of all sorts, but particularly their trademark rights. And the concern is if you let people encroach on your trademark rights, then you steadily erode and lose them. And so Exxon felt that Fox's logo was a little too close and that consumers might be confused, or it might undermine the uniqueness of Exxon's logo. So they sued for trademark infringement here in the federal court in Houston, Texas. And so the Fox Network attorneys hired me as an expert witness to address some of the issues in that case. Under trademark law in the US, at one time it used to be, we had what was called the double identity rule. To show trademark infringement.
Double identity?
Double identity, 2 identities. So it had to be the same mark on the same goods. But this was back at the start of the 20th century. And so under that rule, Fox is not in the same business, obviously, than Exxon. One's an oil company, one's a television network, would not be infringing. But courts over the years in the United States, there were cases, sort of egregious cases, where people would come along right at the border and say, well, I'm not quite the same good, or I'm not quite the same mark. And so eventually we replaced this rule, same good, same mark, with a broad standard that's pretty fuzzy, likelihood of confusion. We look at a number of factors in the US, how similar are the marks, how similar are the products, what's the strength of the plaintiff's mark, marketing channels, sophistication of consumers, actual confusion, good faith, bad faith, things of this sort. But it's a very broad, open-ended standard. And the ultimate question is supposed to be, are the 2 marks similar given the ways in which they're used in the marketplace that an ordinarily prudent consumer would be confused, or at least some of them would be confused and begin to think that the defendant's use was either associated with or affiliated with or actually was Exxon. Now, in this case, it's unlikely anyone's going to think Exxon's gone and created an Exxon Broadcasting Network and used FXX as its mark. But there might be a plausible claim for affiliation or association, licensing, or the broader claim we have in the US for dilution, reducing the uniqueness, the distinctiveness of the double-crossed X's. And so, frankly, I thought the case was pushing the boundaries of trademark law a little too far. And that was essentially what Fox Network had me testify. And that really no reasonable or ordinarily prudent consumer is going to think that this has anything to do with Exxon. The X's are crossed in a different way. But more importantly, right, it's in the television business. People are not going to think Exxon suddenly jumped ship and become a licensee or affiliate of Fox Networks. So that was the litigation. And it took a lot of time and a lot of money to get that resolved. It was fairly expensive litigation. My guess is, though I don't know the actual numbers, that both parties probably spent close to or perhaps over $1 million each just resolving the dispute. And it was eventually settled before trial. So
was this settled? This was settled before trial?
Yep. Almost all litigation in the United States, over 95%, is settled before trial. Right? You get hints about how it's likely to come out. And so why spend the extra hundreds of thousands of dollars to get the jury or the judge to tell you how it's going to come out when you can both see how it's going to come out? Make a sensible business deal for both parties. Both parties are equally unhappy and happy. Usually that's how you know when the settlement is well.
So I had a question. As an expert witness, what was the expertise they were asking? Because on interpretation of law, I'm guessing the courts will have the final say anyway.
That is exactly right. And courts do not like law professors coming into their courtroom and telling them what the law is, because they will get very mad at you. No, my expertise was in how the trademark protection program that Exxon had in place factually for protecting the XX mark. Had they done it consistently over time? Were there a lot of other uses of other firms with XX in their name? And so I was looking at the steps they had taken or really not taken at various points in time to try and protect their trademark rights. We talk about, well, if you don't protect it, you lose it. And so I was examining the question whether they had consistently, and they had not, protected it over the last 40 to 50 years.
So that was as a matter of fact, and you did not have to be associated with either of these companies to be called as an expert witness, is it?
No, in the United States, as part of the legal process, each party and the court can have their own expert witnesses. And if it's a court-appointed neutral expert, then the cost is shared by the two parties. If a party hires an expert witness, they pay the expert's fee. And of course, the expert has to be qualified. They have to be truly an expert in the field. And they have to have testimony that's going to assist the trier of fact to resolve the issue. So trying to testify about law is usually a no-no, though judges will allow it when it's a question of, say, foreign law that they're not familiar with. So they have to resolve an issue of Indian law on a particular point. They may say, oh, sure, bring in an expert witness because we need some advice on what Indian law says, the finer points of Indian law on this particular issue. And that was not the case here. It was a factual analysis.
This was really an amazing case study. And I think we all get the kind of scale at which these matters are disputed or litigated in the US. And thank you for the example. And I have a question from somebody in the audience. He's asking, please talk about trade secrets. I'll just like to share the Indian perspective here. Broadly, beyond confidentiality agreements, we do not have a trade secret law here. So apart from secrecy and confidentiality agreements, we do not have a body of knowledge around it. But I'm aware that there are some legislations in the US at the federal and state level that deal with trade secrets. But it will be great to know from you, from your experiences as a practitioner and an academic, about trade secrets and their commercial, the commercial opportunity for clients as well as lawyers involved to protect and enforce trade secrets.
So trade secret litigation has not grown quite as much as the other statutory areas, but it is now a federal statute since 2018, the Defend Trade Secrets Act. Historically in the United States, it was just a matter of state law. That doesn't mean it was unimportant. It just means different court system you would sue in. In the US, we have both federal courts and state courts. Patent and copyright only in federal courts. Trademark, trade secret, historically, primarily state courts, but could be brought in both. Now, all four can be brought in, well, trademark and trade secret have federal statutes to protect them as well. So you can bring those in federal or state court. But trade secret in the United States under the statute, or in those states that don't have a statute under the state law, would be a common law doctrine. Pretty similar, right? We're looking for information that's secret. And so secrecy generally entails both that it's not commonly known. So if it's something that everyone knows, it's posted on the internet or something of that sort, can't really claim secrecy in it. It has value because it's secret. And so, for example, when you submit your bid as a business on a government project, request for bids or something of that sort, you don't want your competitors knowing what your bid was, or they'll come along and submit their bid or $2 less or $10 less and take that job away from you. So it has to be secret, it has to be valuable, and you have to undertake reasonable efforts to keep it secret. Right? You can't share it widely. You got to have non-disclosure agreements with those you share it with. Share it only with those who really need access to the information to make business use of it. Now, all that being said, it doesn't have to be truly secret. I always joke with my students, how many people can know a secret and still be a secret? And the old joke is 2 if one of them is dead. So it doesn't have to be truly secret, or else you're the only one who would know it, and you wouldn't have to sue unless you were suing yourself for
It is like that Chinese whisper concept, like everybody tells the
Yes.
other person, keep it secret. And if you do it via agreements, then there can be 1,000 people knowing a secret as long as it has not leaked out into the market.
Yeah, well, in the United States, we do it a little differently. So it don't have to have necessarily an agreement with everyone, but it can't be widely known. And so it certainly helps to have agreements with everyone in place if you can.
All right.
So if you do that, then you have a protectable trade secret. Now, the sort of protection you get for a trade secret is not absolute. It's not like a patent. It doesn't protect you against anyone making, using, selling, or offering to sell your patented invention, which is the language of the Patent Act. With a trade secret, we only really protect against 2 forms of misappropriation, it's called. That is breach of a duty of confidence, usually an express duty of confidence that you've gotten someone to agree to, either as an employee or a contractor, or someone else who got access to the information with your consent, but contingent on them keeping a secret. So if there's a breach of this duty of confidence, that's one form of trade secret misappropriation. And often there, the litigation is against former employees who moved from Uber to Google in the self-driving car area. There was huge litigation about that over the last few years, or something of that sort. And part of the difficulty there is drawing a line between what an employee is entitled to take with them when they leave a job, their general skills, knowledge, and training, and what they're not entitled to take with them, which is specific trade secret information. But the line between those is not a line, it's more of a fuzzy gray area, sort of boundary. And somewhere in there, the court's going to draw a line, but it's very hard to predict often where it's going to be. Sometimes it's easy.
This is very helpful.
And then
yes, please.
The second form of misappropriation is sort of the James Bond corporate espionage, right? Where you break into their facility and steal their secret plans, or you're spying on them, or you hire someone to go in and trick them into revealing the information, some sort of mechanism, misappropriation, where you use an improper means to acquire the information. Now, if you just reverse engineer the products they sell on the open market, or you independently create the same information or process, those are not misappropriation, and you're fully entitled to do your own work in the field and sell your own products that you come up with. So it's about taking it improperly from someone else.
This was absolutely amazing. I'm going to invite some of our viewers to share their comments on the chat. There are a few people watching us, and I really invite them to share their comments, their questions. And before we move on, I want to ask you questions about opportunities in Texas and a little bit about, copyright and patent developments. But before that, there's a question that someone asked, a viewer has asked, that how does Texas A&M faculty deal with teaching students who don't have a prior IP background or who don't know much about US IP law? What is the kind of approach, and maybe are students able to follow?
Well, it's all my students typically do not have an IP background when they start the program, whether they're law students. And of course, I do teach at the engineering college as well. I teach intellectual property law for entrepreneurs, trademarks, patents, copyrights. I teach all those courses to the undergrads and graduates in the engineering students, none of whom have any IP experience or background, and they don't really generally have any legal experience or background either. They're being trained as engineers, but they need to know enough so they don't get in trouble while they're working as engineers. So some of them are going to become managers and move up the corporate ranks. So it's helpful to have a little broader experience. But my law students at the start, their first IP course, they may have a little background in law from first year towards property, contracts, civil procedure. But the intellectual property survey or whichever course they choose to start with is going to be their first exposure to the law. All of us at A&M are very experienced at teaching people who do not have, for me, even a legal background. So I'm teaching them IP at a level they can pick up and understand. But there are lots of great, easy to use examples in IP, right? Patent may seem like it's esoteric and hard, but you take a squirt gun, right? The super soaker, when they added the pump action to the squirt gun, and that was patented. So there are a lot of very simplistic, simple technology-wise examples you can use to illustrate far more complex legal doctrine that can get really messy when you get into some technologies like cell phones.
On that note, I had a question, Professor. What do you think, what are the opportunities for someone who doesn't have a training or a degree in science or engineering? What kind of roles can they play in the patent side of IP? Because in India, a lot of people think that, oh my God, I'm not an engineer, I'm not a scientist, so I can't do any work on patents.
Right.
But what would you have to say on that?
We get that same mistaken belief in the United States when students come into my courses.
Okay.
So let's talk about working in patent law.
Sure.
There are three types of sort of work you can do as a lawyer in patent law. You can draft and prosecute patents. That is, you apply for patents on behalf of your clients before the United States Patent and Trademark Office or one of the other patent offices around the world. There are lots of treaties now. There's one major treaty now, Patent Cooperation Treaty. It makes it very easy to get your patent application considered in all the signatory members.
Paris Convention and the PCT.
Yeah, which get you consideration in most of the countries you would care about. So that does require that in the United States to pass the patent bar. And as I said, that generally requires that you have a hard science or engineering background of some sort. The other two areas of legal practice in patent don't require it at all, and to some extent may be a hindrance. And so the first is litigation, where you go in and sue someone for infringing or your client's being sued for infringing someone else's patents. And some of the best litigators, you don't need a license from the patent office, you don't need a hard science background. Some people think it helps to understand the technology better when you're a litigator, if you really understand the technology. And there's something to that. But I've seen the best patent litigators often don't have a hard science background because they want to understand the technology in the way the jury is going to understand the technology or the judge is going to understand the technology. And usually your jurors and your judges do not have technical backgrounds. So the lawyer in litigation with the technical background is explaining the technology at the level, but he understands it so easily and readily because of his hard science background. He's not really explaining it at a level that the jury or the judge can understand, whereas the litigator who has no hard science background had to really work to understand the technology and is much better, has a much better understanding from their own experience what they need to explain for a jury who's not educated in the hard sciences necessarily to understand the technology of the issue. So you don't need a hard science or engineering background to be a patent litigator, and to some extent may be a hindrance. The third area of practice is sort of deal making, transactional work. Could be simple as licensing or cross-licensing a patent portfolio of some type, even an individual patent. Could be more complex than that. You're buying or selling startup firms where a major proportion of their value are their patent portfolio, their portfolio of patents. And so you need to look at, make evaluations of the value of those patents, the enforceabilities, the likely validity of those patents. And you don't need a hard science background to do that. It's really more deal making, business contract law, but it just so happens that the assets you're buying and selling, or primarily buying and selling, are going to be patents.
Wow. So apart from the actual drafting of the patent application, somebody with a non-science background can do patent litigation and transactional work on patents. And there's a ton of both of them, as you said.
Right. And as you said at the outset, with the $18 billion in IP sort of work, right? In terms of patent work, probably about 10 to 15% of the revenue earned by attorneys is for prosecution and drafting patents.
Only 10% is for prosecution.
It's a relatively small percentage because it's relatively inexpensive. When you get into litigation or deal making, that tends to be a more expensive process.
I think that's quite a useful piece of information, because people tend to disqualify themselves looking at just that little tiny 10 or 15%, and they do not know about the bigger 85% pie of patent litigation and transactional work. There is the market in US for this is huge, because for various reasons, but one reason I wanted to ask you about, there is this opportunity. There's a lot of private capital being raised to fund patent litigation. I was reading about it. So that kind of thing doesn't happen in India, cannot happen in India due to the rules here. So I wanted to understand how it works in the US, so that our viewers can have a perspective about the market there.
So it's not exactly a new thing. In the United States, we have generic pharmaceutical companies that routinely challenge brand name companies' patents on their blockbuster drugs, so the generic can introduce a low-cost alternative to help consumers. They make a profit too. Many of those are actually historically run by lawyers. We call them generic pharmaceutical companies. They're really generic pharmaceutical litigation companies. And what they do is they do this litigation, they get the right to enter the market only if they win the litigation or get a settlement agreement that gives them that right. And so they're funding the litigation by the profits they expect to make if they can get into the generic market. And so that was sort of the first form of a corporate entity trying to fund patent litigation off the profits you could make from winning the patent litigation.
Future profits, and of the future profits that you could make.
Off the future profits.
Some investor would invest in that, and there would be a team of lawyers litigating for the company.
That's right.
Okay.
And there would be, sometimes there would be public companies, and that would be, once they had become successful and had a track record and were getting licensing or other revenues from the previous litigations they had won and the generics they had been able to already market, but they would be using that ongoing revenue stream to challenge the next set of blockbuster pharmaceutical patents in order to get into those markets early as well. So from there, it sort of vastly expanded in litigation. We have a group of firms that do the same thing, but on the plaintiff side. So let's say you're a small inventor, or you're a company with limited assets, medium-sized enterprise, or you're facing difficult times. Sometimes you can't afford patent litigation. Patent litigation is hugely expensive. I was saying that Exxon and Fox were each spending over $1 million on that trademark litigation. On patent litigation, serious patent litigation, right? That's a small potatoes, right? You can spend up to $5 to $10 million just on the attorney fees and the litigation. And so a lot of small, medium-sized enterprises couldn't afford that. So they would sell their patent portfolio when they thought that they were not able to enforce it effectively, they just couldn't afford to firms, which in the United States have gotten sort of the non-derogatory term, non-practicing entity or patent finance or litigation firms, or the derogatory name that's sometimes applied to them, patent trolls.
Right.
And of course, it was one of the major defendants that was often sued by these entities, Microsoft, whose lead counsel came up with the term and then popularized patent trolls as a derogatory term. So let's put to one side whether they're good or a bad thing systematically, but they enable small inventors and small and medium-sized enterprises that can't afford the game of patent litigation to still enforce or get some value out of their IP rights. They sell that patent on, sometimes they retain continuing royalties, sometimes they sell it outright. And then those firms go in and enforce them on behalf of themselves or themselves and the inventor as well. Now, some of them are a little more, as with any legal litigation issue in the US, and you sort of have a bell curve of activity. And most of it falls squarely in the middle of the bell curve and is perfectly legitimate. Some of it's really legitimate on the far right side of the curve. But there is a sort of tail on the far left side where you're suing not because you have a valid claim, but just to extort or extract settlements. And they give the rest of the lawyers and the non-practicing entities in this space a bad name for sure.
That's amazing. Thank you. And where do you see the trends in the next decade for IP? Which industries are going to lead maximum work for IP lawyers?
Well, I think we'll continue to see Google, Apple, Meta, that group continue to be sort of the major leaders in market capitalization. And the nice thing about it is, if you didn't ask me in 1990 who was going to be the market leader in 2000, I would have told you the same companies that were market leaders in 1990. Market capitalization leaders such as General Electric or General Motors or some of the banks and things. But of course, over the next 20 years, the market cap leaders changed over almost entirely. And so we don't know who's going to be the next Facebook. We don't know who's going to be the next Google or Apple or Microsoft. But they're in someone's garage right now, chances are, or Tesla, right? And so sooner or later, we'll see them coming. But I think those will be where the work is. And the nice thing about being here in Texas, particularly for those who are interested in patent litigation, is we have two of the federal district courts, one in Waco, Texas, Central District of Texas, and one over in Marshall, Texas, in Eastern Texas, so it's in the, I think, the Northern District of Texas, formerly within the federal court system. That have the sort of largest patent dockets in the country. And so
Wow.
We have
Could
close
you
affiliations.
explain that a little more in terms of size or comparison with other states? Texas has the largest patent docket, like Texas district courts have the largest
These
patent
two courts,
docket.
largest of any states, right? Something like 15% of all patent district court litigation flows through these two district courts in Texas.
Wow.
So more than California, more than New York, more than Delaware or New Jersey, where you might think of as industrial hubs, or even Washington State, Seattle and the like. The state with the most patent litigation is Texas.
So if somebody wants to get into this area, being in Texas really helps, and the credibility of a university like Texas A&M will make a huge difference to them because of the state, it being in the same state and heading the charts there.
Well, when Apple hired me to represent them as an expert, to work with them as an expert witness in the litigation, it was in the Houston District Court, Southern District of Texas. And they wanted a local expert because they didn't want to bring in some New York expert or California expert. Texans are a little provincial. We'd like to hear from another Texan, and we would trust them a little more than someone from out of state, especially a New Yorker. And so they actually looked for a trademark expert who was affiliated with the Texas school, and I was with Texas A&M at the time. And that's a big part of the reason I was picked. And I also have my own credentials, which are
it is amazing to learn from someone who's worked for all these big brands. Could you share more about the business environment or the kind of trade, the kind of businesses that are there in Texas?
So Texas generally has long been a hub for the oil and gas industry, but it's also a hub of maybe not as much as Silicon Valley, but for the computer industry. Texas Instruments, for a long time, a leading computer firm, is located in the Dallas-Fort Worth area. Dell Computers is in Austin. Austin itself is a hub for biotech and computer technology development, probably second in some respects only to Silicon Valley, though there might be a number of other places that could claim they were second as well. And Texas is a very open, business-minded state. We're really growing in population, we're growing in business activities. And the Dallas-Fort Worth area in particular has become a hub for Fortune 500 companies to set up their corporate headquarters. Right? Once you get one or two, it tends to attract others because the environment's well placed for them, and the school systems and other infrastructure needed to support those businesses is in place. So over the last few decades, it's really become a hub for Fortune 500 companies.
And even startups, because there's a lot of venture capital heading that way. There's a lot of support. There's a lot of new startups opening up there. Then maritime trade, etc., has always been at an high in Texas. A lot of seaports are there.
Houston's a major seaport, one of the largest in the country, and the startup industry historically has been focused in Texas around the Austin area, but it's sort of spread out now and pretty much statewide.
And what are the key reasons for Texas being so important now for big corporations and startup industry?
Well, largely it's the political environment. So states like California and New York have become more restrictive and put tighter controls on what corporations can do, raise the taxes. Texas still has no state income tax. You still have to pay the federal income tax, but no state income tax. Has a better school system, better educated workforce. It's cheaper to live and work in lots of the areas of Texas than California or New York, either of the coasts. And so there's just a lot that it has to offer in terms of the workforce, in terms of the infrastructure and the environment where you can come in and run a business without quite as much government intervention or oversight. You still have it. There's still regulations. You still have to abide by the law, but not the close control and sort of the maybe overly strong control that you might get in a state like California. Right? California sort of became rich with the Silicon Valley and the Google and some of the others. And so they drove up, I mean, the price to live in California, either Los Angeles or the San Francisco area, has just gotten ridiculously high. I had a niece who graduated with an architecture degree and got a good job at the architecture firm. And the most she could afford in the Bay Area of California was to rent a room in someone's house because the prices had just gotten so ridiculously high with the salaries that Google was paying its engineers and other staff there in the Bay Area, along with certain other firms. So Texas has just proved to be right place, right time, good combination of elements right now. Hopefully it will continue. And Texas has always been a very pro-business state, very supportive of new businesses.
That is amazing to know. There was this story about your dad having of your dad working in NASA when there was a landing on the moon or something.
Yeah.
What was that time like? It would be great.
It was great. So Dad worked from NASA from its founding until I think 1985. He was a flight director for Mercury. He was a flight director on many of the Apollo shots. He was one of the 4 flight directors on Apollo 13. In my own opinion, though Hollywood has a different version, which is not true, so don't get your history from Hollywood, Apollo 13. My dad was primarily the one of the 4 flight directors. They all played a role, don't get me wrong. But he was the one flight director probably singularly most responsible for the safe return of the Apollo 13 crew. He was in charge on the American side of the Apollo Soyuz test project. I still remember the days the Soviets would come over to visit and have dinner at our house. My mom would make the KGB agents stand out at the end of the driveway. She wouldn't let them in the house. So there's some funny stories there. And then he was the shuttle program manager. He retired about a year before the Challenger disaster. 586. So it was early 80s when he retired from NASA. But yes, he was definitely involved in those early days of the space program. Really made a difference in his life in getting that.
Did his achievements inspire you to be an engineer and later get into protecting IP?
I can't really say that except in a backward sort of way, right? The one thing I said to myself when I went to college is I'm not going to be an aerospace engineer because when I accomplish things in life, I don't want anyone saying it's because my dad opened the door for me. So I went into a different type of engineering, petroleum engineering. I went into engineering because I love math and science. So I did petroleum engineering, and then it was really my mom who wanted me to go into law. She wanted the lawyer in the family. You know how moms can be, right? They're always concerned with how the family appears in getting successful sons. So mom more than dad on the legal choice of career.
Amazing. And there is one more point. If you could say anything about, the value of an IP law program from Texas A&M University, which is offered online and at a very huge scholarship of $20,000 scholarship fee. Anything you would like, what is the kind of like, could you help people visualize the kind of value? Because, if somebody does it offline, they are going to have to like really pay 3 or 5 times more probably.
Yeah, at least that. And
At
then
least
they got
5
living
times.
expensive, and yeah, it's gonna be in closer to 100,000 than what this program is.
Closer to
So
$100,000 for the whole program if they live in Texas and do this.
it depends on whether they're gonna live cheaply or live
Right.
large. So there's some variation there in terms of your living situation, right? Do you have roommates and share an apartment and
Of
things of that
course.
sort? But yes, it could be very expensive. And I wasn't A&M in person. I don't know if it'd be 100,000, but it's going to be considerably more than the online program.
Right.
Easily 3, 4, 5 times. The 100,000 I was thinking of is if you chose to go to a school in New York City or Washington, D.C. in person there,
Yes.
the cost and the living expenses are going to be much higher. for the
I
Bay
saw
Area
I
or
saw
Los
for
Angeles.
Harvard and there was another Boston, I think. It goes up to $80,000 to $100,000
Yes,
inclusive of
very
living.
expensive. It's a little less expensive to come live in Texas, right? As we said, or a less expensive environment.
Right, but
But
it would still be $60,000-$70,000.
yes, for in person.
Yes.
But you're looking for the American credential in the same way that I was hired by Apple to help them out in litigation because I had an affiliation with Texas A&M. There'll be firms that will want to hire you because you have an affiliation with the U.S. law school, Texas A&M, one of the top 10 IP law schools in the country, and really up and comer. We're going to continue to move up the rankings, both the ISP specialty rankings and the general law school rankings. So you're getting a bargain, right? You're getting something that's going to be worth just almost incalculable amount of money to your business down the road as our reputation continues to rise, and you get that entree, that sort of hook that'll help you land some of that US oriented business.
So the credibility of the program as it stands in an offline mode also would stand if they are doing this online.
That's right.
That's
You get our
amazing.
reputation whether you come in person or you come online.
The same kind of reputational benefit they can enjoy, because a lot of times, people in India think that, oh, it's online, that means it's going to be lesser or compromised. But that is not how this program is designed.
No, that is not how the program is designed. Now, of course, if you come in person, you get a greater chance to meet people individually in the Dallas-Fort Worth area. But in terms of the reputational benefits and the other legal training, it's going to be
The rigor
every
of the
bit as
program,
much. What's that?
the rigor of the program, academic rigor, will stay the same.
Oh, hey, I don't go easy on you just because I don't get to see in my class. It's going to be tough.
Right.
And we're going to make sure the students really focus on the material and learn the things they need to know.
So this is very important for everyone to know that, the credibility and the academic rigor stays the same. in the online program as well. And there are many ways that they can actually travel through the to the US to network and build their track record in India. So we've been speaking to some of the potential students about that.
Well,
But
I'm
this was, sorry.
glad you guys are taking care of that.
Yes, yes. But this has been extremely, extremely useful, and I would really like to thank you for your time. If any of the viewers have any questions, this is the last opportunity to share this. Professor Linney is scheduled for 1 hour, and Professor Linney, if you have any closing notes, you can let us know. Any closing comments? It was an amazingly insightful and beneficial webinar. I am pretty sure people who see this anytime on the internet are going to find it extremely valuable, and we haven't had an opportunity to learn and get this kind of an insight from somebody who practices and teaches IP law in the US ever before. So it's one of a first, I think, and I'm really happy, Professor Lani, to be hosting this session. But yes, if you have any closing notes, you may share those.
Well, I'm really proud to be associated with this new program, and I'm really looking forward to teaching some students.
That's amazing. That's amazing. So thank you so much for being on this webinar. And
Thank you for having me.
yes, all right. So we are going to close the session. And thank you to all our viewers for being there and for being with us through the entire session. Thank you, Professor Lunny.